It takes them a couple minutes. You don't have to stand. Now they'll let us know. But
I just copied everybody else.
I certainly understand stretching. I'm going to stand to stretch my legs. Doing a lot of sitting in here. Jury's present and seated. Everyone else may be seated this time. Ladies and gentlemen of the jury, welcome back. Anyone have any exposure, discussion, or research in any way related to the case during the break? Let the record reflect there are no hands. Thank you. Mr. Terry, you may begin the redirect examination.
Mr. Carey, defense's exhibits 3A and 3B. 3A, who took that picture?
I believe that would have been my mom.
And how about 3B? Who do you think probably took that picture?
Probably my mom.
Now, you described earlier that there was a contentious custody battle between Nicole Nachtman and her, between Miriam, your mom, and her Nicole's father, Ronald Nachtman, correct?
Yes.
All right, and you described it as messy.
Yes.
Now, would you, at the same time, you've told this jury that Nicole seemed happy as a child. Was that right?
Yes.
All right. And did you believe she was a happy child?
Yes.
Do you think she was affected by the divorce in any way that you were able to see?
No.
Just speculation.
The question was that you saw. Caution the witness not to speculate, only testify to things that you observed or had personal knowledge of.
I did not see her affected by it.
Okay. And when she grew up, did your mom provide her things?
Yes.
Did your mom, in your opinion, do you believe your mom tried to make a happy home for her?
Yes.
Now, your mom's in the military. Was that right?
She was active for a while, and then she joined the reserves.
All right. And what particular branch was she?
The Navy.
And did she, in fact, recently get a promotion or something?
Yeah, she became a captain, so 06. The Navy.
As part of her work with the Navy and in the reserves, was your mom, was she often deployed?
She deployed to Landstuhl, Germany, while I was in Arizona for about a year or two. But then she was able to. They put her on a lot of different types of orders, so not always deployments, but random TDYs or different types of orders that keep her employed doing that for however long. Yes.
And during those times, she would have to have a place for Nicole to stay, correct?
Yes.
And during one of those deployments, did she stay with your grandmother?
Yes.
Okay. And was she also deployed the year that Nicole Nachtman was living in an apartment by Sickles High School?
I don't know.
Okay, you're not sure of that. Speaking of that, were you aware that the home in Carrollwood was not zoned for Sickles? It's actually Gaither. Did you know that?
I did not know that.
Do you know whether or not your mom got the apartment near Sickles and so in order so that she could continue to go to school at Sickles?
Objection asked and answered. He said he didn't know.
That's overruled. This is a different question.
Can you say it again?
Do you know whether or not she got the apartment near Sickles in order so that Nicole could continue to go and attend school at Sickles?
I believe that's what I found out, yes.
Okay. Now, you've described your mom as demanding, I can believe.
Yes.
Strict. Did you say strict?
Yes.
Do you feel like she wanted you all to excel?
Yes.
Do you feel like any time she was upset or angry with you all, it was because do you know if, as well as Nicole was 17 or so when she got that apartment in Sickles, do you know if your mom wanted her to start being more independent, not being so dependent on, to grow up, in other words?
Absolutely, yes.
Now, when Ms. Hersey-Fulguera described it over and over again as you running away, you were in Tampa, correct?
Yes.
Did you, and you got out of the car because you did not want to go to Virginia?
Correct.
And where did you go?
I stayed at my grandma's.
Okay. So you didn't go out on the streets?
No.
You didn't go try and stay in hotel rooms or work the streets to get away?
No.
So when she describes running away, basically you just got out of the car and said, I'm going to stay here at grandmother's.
Yes.
And you said that in middle school she started to change, around 6th grade, getting close to the teenage years?
Yes.
Would you find it common that people, as they're growing up, start to change? They may not dance and sing like they used to, especially
Yes.
teenagers? You described your mom as wanting her to get LASIK. Did you yourself encourage her to get the LASIK?
I told her, I had LASIK and it was totally fine and it's a good thing to do, especially if somebody's paying for it. So I was like, if you don't want to do it, don't do it, but I would suggest it.
And by this time she's 21 years old, right?
Yes.
And when it came to Nicole's weight or looks, you remember your mom basically just telling you she would say, make sure she's running and eating properly. Is that
Yes.
right?
Yes.
You mentioned that Nicole was scared of your mom.
Yes.
Was she scared of your? Did you ever, in the times that you were home and the times you were around, did you ever see your mom physically hit Nicole?
No.
Did Nicole ever tell you that she was scared of your mom physically hurting her in any way?
No.
Was she maybe scared of not meeting your mom's expectations or getting yelled at?
Yes.
Now going back to the fact that she got that apartment near Sickles, the falling out you and your mom had a few years ago or years before that had to do with the fact that her mom wanted you to get in a good school district up there so that she could come live with you. Is that right?
Yes.
All right. And that was the main reason she wanted you to move, was because of the school district.
Do you object to leading?
No, it's just standard rephrase.
Was it important to your mom that Nicole be in some good schools?
Yes.
Because did she want her to get a good education?
Yes.
Now, I know you indicated you didn't talk for 3 years. Did you all start talking again?
Yes.
At the time your mom was killed, were you and your mom were you all talking and,
Yes.
and having a regular
Yeah.
relationship?
Phone calls, text messages, emails.
You mentioned your mom at one point saying when Nicole told you, her mom said, when she ran into her mom goes, "What the fuck are you doing here?" And you said it's not uncommon for your mom to cuss.
Correct.
And you kind of looked and said your mom cusses a lot. Is that right?
Yes.
Did your mom always cuss when she was angry?
Yes.
Did your mom sometimes cuss when she was happy?
Yes.
Did your mom just sometimes cuss in general about things?
She loved to cuss.
Okay. So it's not uncommon, that would not be uncommon for her to look at Nicole, who's seeing someone who's not supposed to be there, to say, "What the fuck are you doing here?" Like,
Right.
okay.
Yes.
You also indicated to the jury that you felt that Nicole would not be able to function at school.
Oh, FSU?
Yeah.
Like by herself, you mean?
Yes.
Correct.
All right. However, did she not? Did she not go to London on her own?
Yeah, I believe so.
Yeah. And she spent a semester abroad in London on her own. She was able to do that, right?
Yeah, and I had talked about this before. It's really hard for me to imagine her paying bills and things like that, but then she would drive long distances and do things that were kind of surprising to me. So, to say that she can't is, I don't know. At first I didn't think so, but after learning that kind of stuff, it's...
Yeah. Well, she was able to get her housing situation straightened out on her own.
Yes.
In this case.
Objection to leading?
Was she able to
Right.
get her? Was she able to get her housing straightened out for that year?
Yes.
Okay. And do you know if she managed her housing on her own all the semesters?
I don't know.
And she was clearly intelligent enough to get into the Florida State University, right?
Yes.
Going back to the situation of how you indicated she would say, don't tell mom.
Yes.
You said a couple of times she said that. Did you find that particularly strange?
I don't want to say strange. It was over. I thought the reason was strange. I mean, she bought the one I'm remembering is she bought a sword from a Renaissance fair and took a significant portion of the money that my mom was giving her, and so she called and left a voicemail saying, "Don't tell mom. Just tell her you bought the sword if she calls and asks."
Okay, because she didn't want her mom to know she was spending money on things she should be spending money on.
Right.
Okay. But like, for instance, she broke her computer. Did she break her computer one day?
And her laptop.
And what did your mom do when she found out she broke her computer?
Bought her a brand new laptop.
Bought her a brand new laptop?
Yeah.
Just if I may have one moment.
Absolutely.
No further questions, Chair.
Can we approach?
Yes. You don't need to remain outside, but you are subject to recall. But you may step down as a witness at this time. Ready with the stipulations, I believe?
Yes, Judge. At this time, the state would move into evidence State's Exhibit number 68 and State's Exhibit number 69.
Is there any objection to those coming into evidence?
No, sir.
All right, and these are stipulations. Ladies and gentlemen of the jury, stipulations are facts that the parties have agreed to, and I'm going to read them to you. They should be considered as any other facts that you consider in the case. The first is stipulation to victim's identity, and it reads, the state of Florida and the defendant Nicole Jean Nachtman stipulate to the following. The person who died on the 20th day of August 2015 at 14108 Fensbury Drive has been identified as Miriam Carey Beans, the individual named in count 2 of the indictment in this case. We hereby certify that the foregoing stipulation is made in good faith and for reasons herein alleged dated this 30th day of July 2019, and then it is signed by Ms. Hersey Fulgaria, attorney for the defendant, John Terry, assistant state attorney, and Nicole Jean Nachtman. The next stipulation is also titled Stipulation to Victim's Identity, and this is exhibit number 69. The previous was exhibit number 68. Number 69 reads, the state of Florida and the defendant Nicole Jean Nachtman stipulate to the following. The person who died between the 18th day of August 2015 and the 20th day of August 2015 at 14110 Fensbury Drive has been identified as Robert J. Beans, the individual named in count 1 of the indictment in this case. We hereby certify that the foregoing stipulation is made in good faith and for the reasons herein alleged, dated this 30th day of July 2019, and it is signed by Ms. Dana Percy Folgera, attorney for the defendant, John Terry, assistant state attorney, and Nicole Jean Nachtman. Anything else from the state?
Your Honor, at this point, the state rests.
All right, ladies and gentlemen of the jury, state having rested their case, you may recall from the instructions in the beginning that we would now turn to the defense, but we're going to go ahead and take our lunch break. It is 11:30. I'm going to give you till 1 o'clock, so that's an hour and a half lunch today, and then at 1 o'clock we'll come back and we'll pick up with the defense case. Please do not discuss the case amongst yourselves or with anyone else. Do not do any research related to the case and avoid all exposure to any reports about this case outside of the courtroom. All rise for the jury. Please have a nice lunch. Carey has exited. Everyone may be seated. Let me ask by JA, if you can go, I left the case law. I'm not sure if it's on the council or on my desk. What was the name of one of those cases that you gave me?
I wrote premeditation on the
Right,
front
it
of it.
has
It should be
premeditation
Mungin,
written.
should be the first one.
But there's also some of other cases that should be next to it on self-defense. We can get started. She's going to bring me the case law that you gave me right before the break, and I carried with me and forgot in my office.
And Judge, I can tell the court that my JOA for the self-defense issue won't come until we rest.
Okay.
I just plan to address premeditation today. I mean, right now, unless
Right.
the court.
No. I understand.
Did you say you want to get started before?
No, let's go ahead and get started. I haven't had a chance to read those cases yet. I didn't have enough time during the last break, and unfortunately I left them in my office. But we can get started while those cases are being delivered to me.
Judge, the first case I'll cite to is Mungin v. State. That's 689 Southern 2nd, 1026. It's a Supreme Court of Florida case from 1995. The facts that the state presented in this case to support premeditation were that the victim was shot once in the head at close range. The only injury was a gunshot wound. That the defendant had procured the murder weapon in advance and had used it before, and that the gun required a 6-pound pull to fire. But the evidence was also consistent with a killing that occurred on the spur of the moment. There were no statements indicating that the defendant had intended to kill the victim, no witnesses to the events preceding the shooting, and no continuing attack that would have suggested premeditation. And for all of those reasons, the court in this case indicated that premeditation for purposes of first-degree murder had not been proven, and therefore a judgment of acquittal should have been granted. The second case is Kirkland v. State. It's a Supreme Court of Florida case, 684 Southern 2nd, 732. The facts of that case were that the victim was murdered via a very deep, complex, irregular wound of the neck. The wound cut off the victim's ability to breathe and caused extensive bleeding. At the time of the murder, the defendant was living with her mother and her brother, and they were all living in the same dwelling as the victim. When the murder occurred, two of the family members were in Tallahassee. When they returned home, they discovered the dead body of the family member in a bedroom of the dwelling. The facts had indicated that the defendant had actually left and traveled to Atlanta and then to Fort Myers after the murders. The court ultimately found that the evidence of premeditation was insufficient to support a conviction for first-degree murder. The state argued that the victim, having suffered a severe neck wound that caused her to bleed to death or suffocate, was evidence of premeditation, that the wound was caused by many slashes, and that the neck wound that the victim had suffered appeared to be the result of blunt force trauma, so there must have been another wound. There was evidence indicating that both the knife and a walking cane were used during the attack, and that there had been previous friction between the family members, the decedent and the defendant prior, and that was the state's argument as to evidence of premeditation. However, what the court ruled is that the state's evidence was insufficient in light of the strong evidence against a finding of premeditation. And Judge, if you have Kirkland now in front of you,
I did.
I'm on page 2 on the right-hand side.
Give me one moment.
Second paragraph.
You said page 2?
Yes, sir.
Right-hand column, second paragraph?
Yes, the first paragraph is what I just read. That was the state's argument in their hopes of premeditation, and this is what the court ultimately included.
I'm there.
There was no suggestion that the defendant exhibited, mentioned, or even possessed an intent to kill the victim at any time prior to the actual homicide. There were no witnesses to the events immediately preceding the homicide, and there was no evidence suggesting that the defendant made any special arrangements to obtain a murder weapon in advance of the homicide. The court went on to say that the state presented scant, if any, evidence to indicate that the defendant committed the homicide according to some preconceived plan. And the court ultimately held that that was insufficient evidence to support a finding of premeditation. I think both cases are very similar in the sense that Mungeon involved gunshot wounds. Again, no witnesses present, nothing to suggest any premeditation or preconceived plan. And then Kirkland involved the defendant actually leaving town after the homicides and indicating that there had maybe even been some problems within the family between the defendant and the victim, and that was not enough to support a conviction for premeditated first-degree murder. I will analogize it to our facts as soon as I'm done, Judge, with the cases. Norton is the third case, again a Supreme Court of Florida case, 709 Southern 2nd 87.
I've got it.
If you go to page 4 of the opinion, it discusses the lack of premeditation. We find there is a complete absence of evidence to support a finding of premeditation. The total absence of evidence as to the circumstances specifically surrounding the shooting goes against a finding of premeditation in that case. And again, that's what we have. The court goes on page 5 to go through all of the evidence individually. First, there's no evidence as to a possible motive. While we recognize that motive is not an essential element of homicide, whereas here the proof of a crime rests on circumstantial evidence, motive may become important. Second, there were no witnesses to the shooting or to the events immediately preceding the shooting. Third, there was no evidence of a continuing attack, suggesting the possibility of premeditation. Fourth, the state elicited no evidence suggesting that the appellant had intended to kill the victim. Fifth, there was no evidence that appellant procured a murder weapon in advance of the homicide. And finally, the fact that the appellant may have taken steps to conceal evidence of a crime does not establish that he committed the murder with a preconceived plan or design. The third case is Bigham, B-I-G-H-A-M, 995 Southern 2nd, 207.
I'm there. Got it.
Judge, I'll just cite that one for the record. There's really nothing distinguishable from the cases that I've just stated. However, in Hofort, the last case, which is H-O-E-F-E-R-T, 617 Southern 2nd, 1046, this focuses on what's done after a homicide. And I, in fact, cite this case, and I believe it's Norton for the proposition that the jury should be instructed that anything Ms. Nachtman may have done after the killings in no way is evidence of premeditation. And that's what this proposition is for this case stands for. The fact that she may have cleaned up the scene, the fact that she may have driven to Tallahassee after, in no way should be a consideration when determining the elements for premeditation. So now let's talk about our case, Judge, and why I believe our case is similar to the cases that I've just cited. There is absolutely no evidence. First of all, there's no witnesses to either shooting. There is absolutely no evidence, as we sit here right now, to indicate when Ms. Nachtman retrieved that firearm from the gun case that appears to be open. There's not even evidence to suggest, or at least concrete evidence to suggest, that that case had a firearm to begin with. All we have is an empty fire case, and we have a firearm that has not been retrieved. There is no witnesses who testified that the last time I saw that case, there was a firearm in it. Joseph Carey wasn't asked. David Lear, the cousin, who had been to the house several times and says he spent a lot of time there, wasn't asked, where do they keep the firearm? So there is no evidence as to when Ms. Nachtman retrieved that firearm prior to shooting Bob. There's no witnesses to the shooting of Bob. The evidence suggests that either Bob was sitting in a recliner watching a movie because the movie is on pause when the cops get there, or possibly something happens in the kitchen. No evidence whatsoever to establish that she had ever expressed ill will toward Bob. She had ever even made a negative comment about Bob to indicate that she had a motive or a preconceived plan to kill Bob. There is absolutely no evidence to suggest premeditation as it relates to Bob. As it relates to Mom, the facts are a little different, and I'll concede that. She is in that house at some point with a dead body, possibly for a day. However, again, having no witnesses and the evidence suggesting that she's trying to escape the house by exiting out that bedroom window, and as she told her brother, mistimed it, and then there's we won't use the word confrontation, a meeting in the driveway between Mom and her. The fact that she's trying to escape out of a bedroom window and get away from Mom indicates there's no evidence of premeditation. The state has tried to attempt to argue that this was some master plan by Nicole Nachtman to kill Bob, lay in wait with a dead body for a day, and then wait for mom to get there. But oh, by the way, I'm going to jump out my bedroom window when I hear mom pull up. We also have evidence to suggest that that front door is open when law enforcement does the welfare check. So we know mom got there, likely, and came out pretty quickly if that front door is still open by the time Nicole Nachtman jumps out her window. There is absolutely no evidence to suggest premeditation as to either of these counts, and we're asking that you grant our motion for judgment of acquittal.
Let me ask you: is there any case law that suggests if I think that there's evidence of premeditation by parking the car down the street, by laying in wait in the house, but then there's some evidence maybe that she changed her mind? Is there any case law that addresses that, where the prior premeditation is thrown out and she needs a new premeditation after she changes her mind?
Judge, I didn't research that specific issue, but I would point to... Give me a second.
Yes.